President Jacob Zuma says he will meet President Cyril Ramaphosa's deadline to oppose his urgent court interdict. The president filed his papers in the Gauteng High Court on Tuesday, asking the court to stop any further steps by former President Jacob Zuma to privately prosecute him. For reaction on this, I'm joined now by Benedict Phiri, who's a legal analyst. A very good afternoon to you. Thank you so much for your time. I suppose it's D-Day for the former President Jacob Zuma. He has until the end of today to make some moves. He's indicated that he will be opposing Ramaphosa's application for the urgent interdict. Looking at the dynamics of the case, what do you make of this?
I think that was a time period that was set by the president in his notice of motion because he will be applying on an urgent basis for this interim interdict pending a second application he'll bring at a later time to set aside the summons and the nolle prosecute certificate. So I think that was to be expected. If the former president is going to be sticking to his guns, he will file his notice of intention to oppose, and then we expect that he will file his answering affidavit a few days later as well.
Now, a statement from the Jacob Zuma Foundation says that they're pleased that sanity has seemingly prevailed from Ramaphosa's end, saying that this response is a far cry from the stance initially adopted by the president, where it was reported that he's legally entitled to simply ignore the criminal charges and summons issued by the registrar of the High Court. How should this matter then be interpreted? Does it mean that there is legal substance over the private prosecution, or is it simply a matter of procedure that we're seeing at the moment?
I think those initial exchanges were just a matter of posturing between the legal representatives. I think everybody knows that if you receive a summons, you aren't entitled to ignore that summons. You have to approach a court to set it aside, which is what the president has done here. So I don't think it lends any credence to the merits of the private prosecution per se. I think the president has actually done the right thing, or what would have been done in this particular instance if one needs to set aside a summons. And firstly is to interdict the proceedings because, the proceedings themselves should not be going ahead. And that interdict is obviously going to be an interim interdict pending the full application by the president to actually set aside the summons. So this is actually par for the course, and the fact that the president has done this does not mean that the private prosecution has any merit. In fact, I don't think it has any merit at all.
Because we know that this legal action revolves around former President Zuma, who's instituted the private prosecution against Ramaphosa over his alleged failure to adequately deal with allegations of improper conduct against state advocate Billy Downer. Now, other legal experts have also weighed in on this matter, saying the case is perhaps a matter of administrative procedures and not criminal law. How do you see it?
Well, if you look at the president's case and what he's actually saying in his notice of motion, he's saying that firstly the summons should not have been issued by the registrar of the court. Now that is an administrative process, meaning that the registrar should have satisfied himself that the summons actually disclosed a proper crime firstly, and secondly that there was security furnished for the legal costs. And thirdly, there were 2 summonses that were issued, and that should not have been the case. So that is an administrative error in and of itself, and that is a matter that is dealt with, from an administrative perspective. Secondly, the question of whether a nolle prosecute certificate has been issued or has been issued validly, again, is an administrative process that sits with the DPP. And you will see that as part of President Ramaphosa's notice of motion, he has asked the National Prosecuting Authority to actually furnish the record and all the documentation and minutes and everything that went into the decision to not prosecute, so that that decision can actually be tested for its lawfulness and validity and irrationality. So those 2 aspects are administrative aspects and will be dealt with from an administrative law perspective. But obviously the question as to whether the president has committed a crime is a criminal law matter. obviously the administrative processes giving effect to the criminal law matter must actually be adhered to, just like in any other administrative process. But that on of itself, the fact that there is an allegation of a crime, is a criminal law matter. But for now, the administrative processes had to be dealt with, and the President is quite correct that they haven't been dealt with correctly, and they need to be set aside.
So, as a result of this matter, President Ramaphosa has requested that his predecessor pay his legal costs and that an interdict be issued to stop the further steps in the case. What are the likelihoods around that request?
So, generally, if a party loses a legal matter, they will be required to pay costs. That's just a general proposition. There are obviously variations to that proposition. For instance, in constitutional matters and labor matters, that rule takes a different form. But what then you are entitled to request is punitive costs, which the President has requested here, where a matter should not have been brought to court in the first place or has been proceeded with on a vexatious basis. And over and above that, which he's actually done for really the first time we're seeing against Mr. Zuma's lawyers, is a cost against the lawyers. He's done that as an alternative, or has requested the court to do that as an alternative. And the courts have been able to issue what we call the bonus propria costs against lawyers who have been effectively negligent and gung-ho in their approach to matters, and matters that shouldn't have been there. Right? So that if President Ramaphosa succeeds in the matter, I think he will get the costs awarded against the former president. Insofar as the interdict is concerned, and I think this is important because essentially the president has to show two things when he goes to court. Firstly, that there are grounds for urgency for this matter to be heard. And that really means that there's no substantial redress if the matter is not heard on the date it's heard and follows the ordinary course of the court role. And I think, given the nature of the rights that are implicated, the fair trial rights here, the fact that it's a private prosecution doesn't mean he has any less rights than an accused in a public prosecution. And if you consider that a summons is potentially defective, there is no title to prosecute allegedly, and you think that you'd actually start a prosecution on the basis of something that is quite defective, I think the court will find on the interdict basis, well, firstly, they will find that from an urgency perspective, there's probably no substantial redress from the president here, for the president. And secondly, on the urgency basis, there is likely to be irreparable harm to the president. And when you look at the prejudice that's likely to be suffered between Mr. Zuma and the president if the matter goes ahead, I think certainly the president has got a lot more prejudice to suffer if the matter goes ahead versus Mr. Zuma if the matter doesn't go ahead. And I don't think he has an alternative remedy in this particular instance. So I think, the president is likely to, make a good argument for, firstly, that the matter should be heard urgently and that there should be an interdict pending this application that he will bring at a later stage to set aside the summons and the nolle prosequi certificate.
Very well. Thank you so much for weighing in on this matter. Let's leave it there for now. Benedict Phiri, legal analyst, giving us some insight on the former president opposing President Cyril Ramaphosa's urgent interdict in that private prosecution matter. Let's